Thank you, everybody. I think we've got everybody back from coffee and so on. Let me just introduce the panelists. So in the right centre is Patrick Dunbury. He is a full professor at the University of Ottawa's law faculty, and he has practiced international arbitration for many years with two of the most preeminent Swiss law firms. And very impressively, he has also published, I think, about 80 publications, is that right? Including the leading and seminal guide to state succession in international investment law. And to my immediate right, Angela Hay is a specialist also in public international law. She qualified in Australia. She clerked for the Honourable Justice Mortimer, the Federal Court, and she gained distinction at the very impressive Oxford University BCL course focused on public international law. And she is now counsel at Volterra Fietta and advises governments in particular, as well as private clients, on a wide range of public international laws. And she is, I think it's fair to say, a formidable and ferocious defender of states, including defeating claims brought by aggressive US investors against states, and successfully for Southeast Asian state. Your specialism extends in areas beyond national jurisdiction. That's what you're going to focus on, Angela, today, and you make an invaluable member of the panel. And finally, Andrew Flower, to the far right, is a partner with HKA. He has a wealth of expertise in quantifying international disputes. He is preeminent testifying expert and a fellow of the Institute of Chartered Accountants in England and Wales. He's also recognized as a global thought leader on issues of quantum in international arbitration. He's testified, really across the globe, I think 40 litigations and arbitrations, and in particular has experience of quantifying issues in the context of public international law, and worked, I think particularly interesting, and maybe you have some more stories, but worked as a senior accountant advisor to Kuwait following the first Gulf War. So that's the panel. We're going to kick off then, I think, with Patrick, who's going to talk us through some of the issues that come up in relation to state succession in the context of international investment law. Patrick.
Thank you so much. Thank you so much for having me. Thanks for your presentation. So today I will deal with one specific issue, which is state succession to BIT. So basically, the question is a new state, successor state, bound by the BITs which have been entered by the predecessor state, which is the old state. So the issue has arisen in about 50 arbitration cases already. Most of them were under the radar for various reasons, I can mention. Some of the issues, of course, is that some of the awards are confidential in the context of Crimea, for instance. But these cases, they always involve the same pattern. So you have, and I'll give you an example, you have a French investors making an investment in Croatia after the independence of Croatia. So that is after the breakup of Yugoslavia. And then you have a French investor filing a claim under the Yugoslavia France BIT. And obviously, what is the problem? The problem is that Croatia is not a party to this BIT. Of course, the BIT was entered into by another state, Yugoslavia, with France. And then the question is, does a tribunal have jurisdiction over that case based on that BIT? In other words, the essential question is a new state automatically bound by the treaties of the old state, in that context, Yugoslavia? So in the first part of this presentation, I will explain my basic argument that there is no automatic succession to BIT. In the second part, I will show that sometimes there is continuation of a BIT when there is express consent by the parties or tacit consent by the parties. So the first essential question is, what does the law say on the matter? Oh, wait, I should move that for a second. Whoops. So, So the first question, obviously, to look at what the law says. And here you have Article 34 of the Vienna Convention on Succession of State, applicable in the context of separation and dissolution of state. And what is interesting is that Article 34 says that there is actually automatic succession to the BITs in the context of separation and dissolution. So Article 34 says there is automatic succession, but the rule was never really applied by states. In their actual practice, what they do, states, they go through negotiation and they simply either continue a treaty or enter into a different treaty. So Article 34 was never applied in practice, and their actual relationship, state don't use that rule. And in my view, the rules of automatic succession doesn't make any sense in real life. And the reason is very simple. The question is very simple: is why this rule does not apply, state have not applied. It's because of the unique nature of bilateral treaties. So Special Rapporteur Walder called it the voluntary character of these bilateral treaties. And also he spoke about the personal equation between the parties. So there are basically two reasons. The first one is that the specific allocation of rights and obligation between parties essentially depends on who the parties are. So it depends on many factors. One of them is the comparative strength of their economy, and also of their political power, their geopolitical influence, and also depends on their special relationship between them and the specific interests of each state. So essentially, from the mere fact that France, 2 decades ago, signed a BIT with Yugoslavia, you cannot infer in any way that it would sign the exact same BIT with Croatia, Slovenia, or Serbia. So essentially, a negotiation between France and Croatia would automatically lead to a different result than the BIT between France and Yugoslavia. Why? Because they are basically different states with different strength. And I'll give you an example. In a previous life, I was working at Foreign Affairs Canada. I was heading negotiation with Vietnam. So at some point, I asked the Vietnamese for some type of clause, and they refused. And I said, we want Canada the same type of clause that you gave to Japan in another treaty. And I showed the treaty. And he looked at me and says, well, you are not Japan. Okay, then we took a break because it was a bit offensive. I said, let's take a break. But in reality, what he was saying is that as a state, we make compromise with big, powerful states like Japan, but not a small state like Canada. Okay, so it really depends on who the parties are. So second reason is that these bilateral treaties are based on reciprocity. It's based on the specific interests of each state in the context of a bargaining negotiation between them. So if state A is willing to give some turn right to state B, it is precisely because state B is also in return giving other right to state A. In other words, if you give me this, I will give you that. And if you give me this, I will give you that, doesn't make any sense if the two parties are not the same. Makes sense in the context of Yugoslavia, France, BIT, but not in the context of France, Croatia, BIT. So in sum, a new state like Croatia is not bound by the treaties. It doesn't have the right to be party to the treaties which were concluded by Yugoslavia. And this is where it's really important. Both France and Croatia, they must consent to the continuation of the treaty. Otherwise, it doesn't exist between them. And how can this be done? This could be done through express agreement between the parties, and it could be done, and this is much more tricky, in the context of a tacit agreement between the parties. So let's start with an express consent. So you have very often parties like Croatia and France deciding to continue an old BIT for their own specific reason. And this is typically done through negotiation and an exchange of diplomatic notes. So let's look at two examples of such a situation. You have states need to agree to the continuation of the BIT. First example, this is Czech Republic. So Czechoslovakia was party to 16 BITs at the end of its life, at the moment of dissolution. Czech Republic agreed with all states for the continuation of all BITs. So these 16 BITs basically became BITs to which Czech Republic was a party. If you look at the example of Montenegro, completely different. You have 36 BITs which were signed by Serbia, Montenegro at the time of the arrival of Montenegro in this new state. After 50% of the state have agreed to continue the BITs, 50% have decided not to continue the BITs, and a few have entered into new agreement with Montenegro. So what these two examples show is that it's not only, what really matters is not only what the new state wants, but more importantly, how the other state reacts to this willingness. So, and a good example of this case is the Diri Pasca Montenegro case. So disclaimer, I was an expert from Montenegro in that case, but the Swedish setting aside proceeding is available in public, so I'm not going to say anything secret here or confidential. So you have a Russian investor making an investment in Montenegro, and then, of course, based on the BIT between the Federal Republic of Yugoslavia and Russia, that was signed in 1995. So a bit later, the Federal Republic of Yugoslavia changes name to Serbia, Montenegro. It's the same state, same international personality, so no complication here. Serbia is, of course, the continuing state, so it is bound by all these BITs. The essential question is the following. Is the new state of Montenegro bound by a BIT which was signed by the old state, Federal Republic of Yugoslavia? If the answer is no, it means basically that the tribunal doesn't have jurisdiction because it believes that there is no BIT between the two parties. So the first thing that the tribunal did, it acknowledged that an agreement could be in the form of simply an exchange of notes. So there's no need for a signing of a BIT. An exchange of notes with an offer and an acceptance is enough to conclude that the BIT exists between these two states. So the tribunal first had a look at some very general proposition, statement, declaration, which were made by Montenegro, which said that we are bound by all the treaties which had been signed by the state union at the time. The tribunal said this was at best an expression of political will and nothing more. I mean, these general statements do not mean anything in terms of binding a relationship. So in other words, Russia is not bound by this very general declaration. So in a first note, and this is where it gets really interesting, in a first note, Montenegro sends to Russia, Montenegro says it confirmed its readiness to observe all treaties and agreements affecting between Russia and the state union. So importantly, Montenegro did not say that it was bound by these treaties. It did not say that it considered that these treaties remain in force. It only says in that context, readiness means let's talk. Let's talk about these treaties. Let's see what happened to these treaties. So an offer, I put it in brackets, was made by Montenegro, and the response by Russia was even more vigorous. Russia said it would take into consideration Montenegro readiness, okay? So the tribunal basically said this was a non-committal response by Russia, and the Swedish court agreed. They said it was a reply that merely bypassed the proposal with silence. So at the end of the day, the tribunal said that there was no formal offer that was made, and there was no answer to a non-offer. So therefore, there was no continuation of a BIT, and therefore, the tribunal said that it did not have competence jurisdiction over that case. So what does this case shows is that, you know, continuation can be done through an exchange of notes, but at the very least, there must be clear evidence that both states agree to continue that BIT, and a simple exchange of note like the one we've seen here is simply not sufficient, according to the tribunal and according to the Swedish court. So now let's move to the other topic of tacit consent. And there, tacit consent is a bit more complicated because it really depends on the circumstances. And you really need to look at the diplomatic correspondence and the conduct of state. So tacit consent can be done through the conduct of state. some statement of state, and it's also some agreement. Let's look at two examples. A very general example. The first one is a general declaration made to the whole world. 1991, Alma Ata Declaration. Some of the former republics, they make a declaration that they feel that they are willing to be bound by all Soviet treaties. So it's not entirely clear whether or not this is a clear intention from this republic to be bound, really bound by all these treaties, given that this declaration was made few days after the independence of each of these new states. So what is clear is that that declaration is not binding on the other state. So what matters is not so much what these republics are willing to do in the abstract. What really is relevant is to see how the other states reacted. Most of the states reacted in a way as follows. They said that this is a general statement. We don't feel that there's a connection. We don't feel that these BITs are binding. Let's negotiate new treaties with Kazakhstan, Kyrgyzstan, et cetera, et cetera, et cetera. So in this context, and most of the states said nothing. They never respond to that general willingness. So in that context, silence doesn't mean anything. It doesn't mean that there's a tacit agreement. Silence means nothing in that context. Let's look at a different example where you have a declaration that is made to one state specifically. And so this is an example between the Bosnia and the Netherlands. So in the first letter, Bosnia said that it feels bound by all the BITs which have been concluded between Yugoslavia and the Netherlands. And Bosnia says these treaties, they remain in force. We believe that they remain in force. And then Bosnia added that he would appreciate if the Netherlands would actually respond to that letter, and the Netherlands did. But what if the Netherlands did not respond? What if this letter was left in silence? What would happen? What would silence mean in that context? So it's a very complicated question. At first, it really depends on the specific circumstances, but at first, in general, silence would mean no tacit continuation in practice. In general, that would mean that. But one has to be careful, and one needs to go further with the analysis, and there's a possible exception. The possible exception is to look at the actual practice. So what did the Netherlands and Bosnia do in practice, in real life? I'll give you an example. The Dutch authorities continue to apply to Bosnian products the exact same tariff which were set out in the Netherlands, Yugoslavia BIT. Okay, that's the first example. Second one, Bosnian planes, trains, probably not trains, but planes and ships, they can come into the territory of the Netherlands based on the exact same condition which existed in the Yugoslavia Netherlands BIT. And this example, the conduct of the Dutch authorities, which are in practice are continuing these treaties, they could show that the Netherlands has actually tacitly agreed to the offer that was made by Bosnia. So the Netherlands would have never said yes, but in practice, it continued this BIT. So the answer is yes to the continuation of this BIT. So the question was very central in the WWM versus Kazakhstan case. Disclaimer, I was a counsel for Kazakhstan in that case. The award is confidential, so I cannot say much, but it doesn't matter for my presentation, you'll see why. So this is a claim where you have a Canadian investor filing a claims against Kazakhstan based on the 1989 Canada-USSR BIT. And the question, of course, is Kazakhstan, as a new state, bound by this BIT between Canada and USSR? So there was no new BIT between Canada and Kazakhstan, and there was no exchange of notes. There was no offer, there was no proposal, there was no response. So everything was a bit in the air. The tribunal did find that they had jurisdiction and that there was a continuation of the BIT, and it did so based on the conduct of the parties. I know what the conduct of our parties was. You cannot know, but it doesn't matter. I will explain why in a second. So you have a second case, which is Gold Pool versus Kazakhstan. So you have the same treaty, the same pattern, the same evidence, different panel, arrives at a different conclusion. It says that there is no continuation of the BIT because there is no state conduct in favor of that continuation. So the award is confidential, but it doesn't matter because the High Court, in a setting aside proceeding, they basically reversed that decision and they said that there was a continuation, there was a conduct by the state, which apparently, according to the High Court, there were evidence that both parties wanted to continue the BITs. And the single evidence that was the most relevant was a trade treaty signed in 1994 by Kazakhstan and Canada, where in the preamble, there was a mention of the 1989 BIT between USSR and Canada, and the parties only said, we're going to take into account this treaty, and the High Court of London indicated that that was enough. There was conduct that was sufficient to prove that both parties were under the impression that a BIT existed. And what is really interesting is that the High Court judge gave no weight at all to a letter from the Ministry of Trade, Canada Ministry of Trade, explaining to the foreign investor that there is no BIT. So the minister explained to the investor, we as Canada feel we have no BIT relationship with Kazakhstan. And the judge basically set aside this letter, and he said the minister was wrong. So, in other words, these two states, what they show is that the continuation of a BIT is very much fact-driven. It really depends on many circumstances and factors, and it really depends on the relationship between each states. So what is also very important is that the exact same type of evidence can be given completely different signification and interpretation depending on who is looking at it. In conclusion, so what does happen if you have a situation where there's no express consent and there's no tacit consent? Then I go back to the first point I made. There is no general succession to BITs. So a new state is not bound by the old BITs. There need to be some sort of consent, either explicitly or tacitly. Every tribunal that I've seen so far have based their analysis, have based it on this assumption of no continuity of treaty. So in my view, I believe now this is a well-settled principle of law. Thank you so much.
Thank you, Patrick. That was incredibly insightful. I'm sure it's given you a lot to think about. If you've got questions, please do raise your hand and let me kick off with a couple of things that occurred to me as you were talking. No automatic succession of BITs, and then in the grey area, a deep dive into what was said between the states, looking at, probably quite a detailed, in-depth dive. Where is the investor in all of this? Where are the investors' legitimate expectations when they went into the investment in a particular territory, expecting and relying on the BIT protections?
Yeah, it's a good question. So in the context of the gold pool case, the investor asked its own government, if we invest in Kazakhstan, do you think there's a BIT? And then the government said no, but apparently the answer was yes. So I guess for the investors, really, it's very tricky. He doesn't know. So what is very interesting is that the investor's position is not really taken into account. But what is also very interesting in the context of the WWM versus Kazakhstan case, Canada took a very, very explicit position in favor of succession. So they had a non-disputing party document explaining that, according to Canada, it always felt that there was a BIT with Kazakhstan. Well, I was working at Foreign Affairs for 3 years, and no one ever told me that. But that doesn't matter so much. So the investor is not really taking into account in this context.
And therefore, if the investor has made the investment and there's regime change, it's going to be tough luck.
Exactly.
Any questions arising? Yes.
I might be confusing my Vienna Convention, but I think the succession convention has... Okay, Christina Schutz, Clifford Chance. I might be confusing my Vienna conventions, but I think the succession convention is one that has entered into force. Is that right?
Yeah.
So Article 34 must have come from somewhere. I take you to be saying that it's not customary international law, but there must have been consensus in the ILC and otherwise about needing this provision. I was wondering if you could comment on that a bit.
Well, thank you for the question. So Article 34 deals with multilateral treaties and bilateral treaties. So with respect to multilateral treaties, there was some practice. And it's controversial whether or not Article 34 is customary or not, but one can defend that position. So there was state practice. But what is interesting is that, and I've read everything about the ILC, there's not one single mention of bilateral treaty. We don't know why they were applied. And what is really striking is that the opposite solution applied in the context of newly independent state. So for newly independent state, it matters who is the other party. Reciprocity matters, but not in the context of dissolution, not in the context of secession. So it might be, maybe the ILC, they simply overlooked the issue. But there is no mention in the travaux about the ILC about why in such a situation of bilateral continuity in the context of secession and dissolution, why should that principle of automatic succession apply? There's just simply nothing.
Thank you. We're going to come now to your question, but before we do, if we can bring the mic down or pass it back. But I just had a very quick follow-up question.
Can you raise your hand whoever wants to ask the question?
Was here.
Oh, yeah.
So just one very quick follow-up question. It sounds like what you're saying is that if you want protection as an investor, you need to engage with your government, make sure that there is a particular specific negotiation with the new successor state to ensure that continuity of protection. But do you think there should be the development of some sort of customary duty to negotiate in good faith when one state starts that kickoff, by the way, we're ready, or, let's sit down and negotiate something new?
Yeah, there should, but in the context of, let's say, Canada, Kazakhstan, at the time, Kazakhstan was a new state. It had a low capacity in terms of international law knowledge. So the letters from Canada, the response from Kazakhstan, they were vague in all senses because probably Kazakhstan didn't know really at the time to which treaty it should adhere. So there was vagueness in the air, literally. And it should have been Canada's position to say, listen, let's be clear, our investors are going to invest in your country. Are you bound or not? But there was never such a declaration. Everything remained vague for some reason I have no clue about.
Please.
Thank you. Great presentation, as you know, in a field I'm interested in as well. First of all, I want to say I agree entirely that this is an area of international law that is characterized by negotiated solutions rather than by default rules. And just to add one comment on what was said just now, the Human Rights Committee in General Comment number 26 endorsed the idea of de jure succession to the ICCPR. So that goes to the notion that in treaty relationships that are not, to use the traditional language, personal, there is more of a case to be made for automatic succession. I want to ask one question, though, which is the following. I take it that your argument is not specific to investment treaties, but would also apply to, say, social security totalization agreements, double tax treaties. It's treaties of a similar nature that grant reciprocal rights and obligations.
Yeah, exactly. So my position is that what I just said, applicable in the context of BIT, would be applicable more generally with respect to bilateral treaties. And then again, it's the ILC showed that there was some practice in the context, and then there is an exception. So the ILC mentioned that in the context of trade agreement, there were situations where there was some continuation, but it was always based on negotiation, exchange of letters, etc. So my view with respect to the non-succession position applies to BITs and more generally to bilateral treaties in general.
Yes, please. Could we pass that?
Jan Boudega, Graduate Institute. I've got a question concerning the acquiescence of the treaty, so the tacit agreement to be bound by them after the succession. How would that work what would be an example of such tacit agreement by applying the treaty
Mhm.
in situation of a very, very simple BIT, just providing for simple protection? Would the simple not infringing the rights of investor be considered as acquiescing those rights, or it's not sufficient?
It's a very, very good question. I'm not sure I have the answer to that question, but in the context of, let's say, a BIT, an element of tacit consent would probably be the fact that an investor said, well, the home state says to the investor, you know, informally, you are protected because you're a Canadian and we feel we're bound. But it would probably be no exchange of letters between the two countries. It would be probably a letter to the investor. And there is the issue of legitimate expectation. Kazakhstan says to the Canadian investor, well, you know, anyways, you will not have to go before the Kazakh judge. You're protected by the BIT with Canada and USSR. In that context, that would be a tacit consent, even though, of course, Canada and Kazakhstan have not participated directly. So that would be an example in my view. But I mean, I don't see other example.
Yes, please.
This may take us outside the realm of the law of treaties, but where does the bindingness of unilateral declarations come in, if at all? So let's say we have a succeeding state who says, I'm bound. So Kazakhstan, I feel that I'm bound. Canada says it doesn't feel it's bound, but a Canadian investor accepts the offer.
Yeah.
The ICJ has given some credence to the bindingness of unilateral declarations, and certainly in investment treaty, well, not investment treaty law, but investment law. Foreign investment laws are deemed by many to be unilateral declarations and have some sort of international character. Could you see a tribunal, you know, assuming jurisdiction, saying whatever the legal significance of Canada's diplomatic note or its failure to answer, there is still some bindingness there and a valid acceptance and an offer to arbitrate on some theory informed by unilateral declarations and their normative character?
In my view, that would be very most unlikely, given that, you know, the answer to the unilateral declaration that needs to be made by the states and not by the investor. Because otherwise, I mean, if you apply the same rhetoric, you know, treaties are no longer, you know, who are the parties to treaties? I mean, it would be anyone. You know, I have a treaty with Kazakhstan, with Moldavia, whatever. So in that context, I mean, I don't think any arbitral tribunal has jurisdiction, you know, under a BIT. There need to be a consent by both states. The investor's consent in that context is not relevant. It could be relevant in the context of specific expectation arising from declaration made to the investor. So you are protected because we feel that Kazakhstan is bound by the treaty. That could be the only exception. Otherwise, the power of a unilateral declaration is limited, very limited.
And I suppose then, Conway, you might be looking at a different scenario where an investor has jurisdiction under a domestic investment law or a private contract with that kind of a promise, but perhaps not then with a BIT to which the state has somehow unilaterally succeeded by agreement with an investor only.
No, completely admit that we're outside the realm of treaty. We're wondering if there's some innovative way of still seizing jurisdiction.
Excellent. I think unless anybody has any other questions, I think it's time is moving on, and I don't want to keep everybody from being the intervener between their drinks. So Angela, over to you, if you can load up your presentation.
I'm not sure that I can, but we'll try.
And just to introduce the topic, Angela's going to talk about another very interesting and difficult area of investment law, addressing investment protection going beyond national jurisdiction. And we're going to go into the high seas, into the seabeds, and into outer space. Take it away.
Thank you, Penny. It's a somewhat ambitious topic, and so I paused a little when Yarrick offered it to me, but it's incredibly interesting. And I don't pretend today to have all the answers, but I'll certainly try to leave you with some interesting food for thought. I think it's fair to say this topic of investment protection and areas beyond national jurisdiction, the high seas, the deep seabed, beyond national jurisdiction, outer space, it's a topic that's largely sat at the margins of international investment law. But with increasing focus on deep sea mining and space activity in particular, it's set to become an increasingly important zone of economic activity. I should say, of course, the usual disclaimer that all views today are my own. They don't represent my firm or any of our clients. My presentation today will broadly seek to cover 3 topics. And those 3 topics are, first, where is the territorial nexus when it comes to investment in areas beyond national jurisdiction? Where and how do we locate the host state? The second question is, who is causing harm to an investment in an area beyond national jurisdiction? Is that the host state, or is it a different third party? And if so, what remedies might you have under international investment law? And the third question is then, if harm does not come from the host state, what else is there in terms of investment protection? What other remedies might you have under international law apart from international investment treaties? So turning then to the first question, where is the territorial nexus? A number of speakers already have touched on this today. Territory remains a mainstay of international investment treaties. And so you might then be forgiven for wondering, if you have an investment in an area beyond national jurisdiction, how do you find a host state? And on the screen now is an example of one statement from the SGS Tribunal indicating that investments made outside the territory of the respondent state may not be covered by the BIT. And drawing on this, there are some authors who've suggested that when it comes to deep seabed mining, for example, because it sits outside territorial scope, it may sit outside the scope of any BIT protection. But to me, leaving aside the question of whether benefit is enough, I think this approach perhaps misses an important reality that all investment in space, deep seabed mining will always have some sort of territorial anchor. And so to put it differently, no investment is really an island. And so when it comes to even high seas fishing or outer space activities, any corporate actor will have some sort of link to a state, and therefore arguably some territorial anchor to one or maybe more than one host state that might then trigger a degree of BIT protection. And so Professor Schreier had mentioned the SGS and Philippines case that involved pre-shipment services carried out necessarily outside the Philippines. And there was an argument by the state that therefore it fell outside the scope of the BIT, outside its territorial scope. But among the facts of that case was also a recognition by the tribunal that there was a coordinating office located in Manila with a number of staff who played a coordinating role. And there the tribunal found that because there was a non-severable substantial aspect in the Philippines, that was enough to bring it within the scope of the BIT, even though the tribunal did accept that the bulk of the activity was carried out outside territory. And it seems to me that in much the same way, when it comes to various kinds of economic activity beyond national jurisdiction, you're often still able to identify some territorial anchor, perhaps in quite orthodox ways. So we might think of the example of the relationship that a deep seabed mining contractor has with the sponsoring state that then sponsors its application to the International Seabed Authority. We might think of the grant by a state of a fishing permit to engage in high seas fisheries. And we might also think of the grant by a state of satellite spectrum leasing in connection with space activities, which have already given rise to certain investor state claims against India, for example. And it seems to me that these sorts of scenarios are likely to meet what the Methanex tribunal had termed a legally significant connection with a host state. And I would suggest that we can continue to use these tests to identify a territorial anchor when it comes to activities beyond national jurisdiction. But then finding that nexus is really only the first hurdle, because we also need to consider an important factual dimension of where the risk or the harm to the investment might come from. In other words, whether the source of the risk and the host state are the one and the same. And we know, for example, from the Bayview in Mexico case, that mere effect on an investment is not enough to trigger BIT jurisdiction. And so in the Bayview case, this was a case where there was an identity between the host state and the source of the harm. The facts involved domestic irrigation investors in Texas who had brought a NAFTA claim against Mexico, alleging harm from Mexico's water regulations. And there the tribunal declined jurisdiction on the basis that merely being affected by Mexico's measures was not enough. It was also necessary to show a legally significant connection with Mexico that hadn't been made out in that case. And it seems to me that the same sort of challenge is likely to face any number of investments in areas beyond national jurisdiction. And whereas on the one hand, when it comes to conventional terrestrial investment, you have activities taking place within an area of control of the host state. That isn't true when it comes to areas beyond national jurisdiction. In fact, by definition, you have activities taking place in a zone that isn't subject to any monopoly of sovereign rights and can't be appropriated by any one sovereign state. And so when it comes to these kinds of activities, you have investments that might then face risks from a very wide range of third-party sources. So for example, if we think of the deep seabed, there's the prospect of potential harm to a private investor from not only their host state or sponsoring state, but from other contractors, other third states, perhaps the International Seabed Authority that's tasked with the granting of licenses under UNCLOS. If we think about outer space, we have very real prospects of harm from space debris and also from satellite spectrum interference. And that might then be traced back to the acts or the emissions, again, of a third-party state. And if we're in that realm, international investment law doesn't really offer any obvious remedy because there's no legally significant connection. There's a factual connection, but not a legally significant connection with the source of the harm. And that is very different from the position that we see in international human rights law, where sometimes even quite fleeting connections, fleeting exercises of factual power can trigger jurisdiction. And so here we can think of Percy Jamar, Italy's interception of migrants on high seas, or Alejandro in Cuba, a case concerning shooting in international airspace. And both those sets of facts were found to be sufficient to trigger human rights treaty application. But as a number of speakers have already referred to, that really comes from quite different treaty language referring to persons within jurisdiction. And so it seems to me that it's not at all obvious that that kind of human rights reasoning can really be transferred over to the different scenario of a BIT, such as the one shown now on the screen that refers to territory. So if you're not within the scope of a BIT, you then need to look to other kinds of potential remedy under international law. And I'll turn to that in a moment. Before I do that, just a couple of brief observations about potential challenges on the merits if you are within a BIT. The first is that any claim of legitimate expectations may well be very difficult given the inherent risks of investing in a still emerging highly regulated sector like deep sea mining or space activities. And so investors do need to take very seriously their own due diligence obligations. They need to anticipate the likelihood of regulatory change. They'll be assisted if they can obtain specific assurances, but in practice that may be very difficult to obtain from a state. Federico spoke about FPS. What work is there for FPS in relation to preventing third-party harm in areas beyond national jurisdiction? I think the factual problem is going to be, what does due diligence really mean when it comes to third-party space debris, third-party overfishing on the high seas? I think factually that's going to be tremendously difficult. And so when it comes to investment in areas beyond national jurisdiction, it seems to me that if you can show something much more straightforward, like arbitrary interference or license cancellation by the host state, you might then be on safer ground. But turning then to what other options might then be available for investment protection against non-host state harm. And here I would say we can look at both quite new remedies and also some of the old traditional remedies. In the camp of new innovative remedies, we have specific rules in UNCLOS in relation to deep sea mining. And here UNCLOS does allow private contractors in certain circumstances to bring claims directly against the ISA. And it can do that through uncertainties, commercial arbitration, or indeed directly to ITF, to the Seabed Disputes Chamber. And in fact, the ISA, because it acts as the regulator under UNCLOS, the regulator for deep seabed mining in the area beyond national jurisdiction, there's potential for these provisions to offer the same kinds of protections that we might usually see in terms of challenges from investors to a host state in relation to conventional land-based mining. This innovation within UNCLOS can then be contrasted to the quite different position under international space law, because when it comes to space law, the key instrument, the 1972 Space Liability Convention, really offers private operators no relief, no remedy at all. Instead, it contemplates that in a case of outer space damage to a space object, it contemplates only state-to-state claims brought against the launching state of the object that's caused harm by the state of nationality of the object, of the operator whose space object has been harmed. And it contemplates that that state-to-state claim is to be resolved through diplomatic negotiations, failing which you might then go to a claims commission, but that claims commission only has recommendatory powers. And so that's clearly a position that's far from satisfactory, particularly at a time when the space economy is increasing exponentially and faces increasing risks of space congestion, space debris. Now, I focus largely today on outer space and deep sea mining activities, but it's also important to note that activities in areas beyond national jurisdiction have a very long history. And in fact, we have examples of diplomatic protection being used in the context of economic activities in areas beyond national jurisdiction. And that we see in the 19th century 1893 Bering Sea fur seals arbitration, which was an early dispute between the US and Great Britain arising out of actions by the US on the high seas to safeguard collapsing seal colonies on US islands. And there the tribunal found in favor of Great Britain, finding that the US had no right to protect seals beyond the limits of US coastal state jurisdiction. And it was a decision that paved the way for an eventual claims commission award of over 17 billion in today's money in respect of the British sealers who had been wrongfully arrested. It's worth noting that, in fact, that dispute wasn't only about monetary compensation. In fact, at the parties' invitation, the tribunal also prescribed a series of regulations to grant proper protection and preservation of the fur seal population. And you'll see a number of those measures now on the slide. And so in a way, what we're really looking at is an early environmental protection case about the sustainability of economic activity in areas beyond national jurisdiction. And the regulations that were prescribed and the negotiations that followed paved the way for the codification of similar rules in what was then the first ever International Wildlife Protection Treaty. I'll conclude with a few brief thoughts on the likely future outlook. I think it's fair to say that increasing economic activity in areas beyond national jurisdiction particularly the deep seabed and in outer space, is going to focus attention on current gaps in the law, including around the protection of investments. And perhaps also questions around long-term sustainability, for example, in the outer space environment. And it may be that in the coming years, we'll see emerging investor-state claims or other kinds of disputes that test the limits of existing law. And when that happens, that might add clarity, or it might simply highlight shortcomings in the regime, or both. Given the range of risks that are there and the limits of existing law, I think we'll see an ongoing role, an important role for diplomatic negotiations. And we may well see specific incidents or disputes that act as circuit breakers to generate constructive engagement and development of the law, as had been the case in relation to the 19th century seals crisis. And there's a possibility that that discussion engagement might then lead to new rules and standards and generally increased functionality. But I think it won't be easy, and it's far from guaranteed. Thank you.
Thank you, Angela. That was absolutely fascinating. And I think for many of us, quite an innovative leap into the realms beyond national jurisdiction. Very happy if people have got questions, but perhaps we could just come back to, and I'm happy to open the forum to all of our speakers, but come back to this issue of diplomatic protection, because it's come up on various panels, and this increased potential increased use of diplomatic protection going forward. That historically has been used in the context of property, but many of you may know that the British government invoked it in relation to an individual, Nazanin Zaghari-Ratcliffe, when she was taken as hostage. And what we've seen is an increase by states of taking hostages as leverage, very sadly, most recently, but also in retaliation for investor state claims. So the question that I had was, do you think that diplomatic protection will be increasingly extended in relation to individuals, or are states going to try and keep that as a property protection?
I think it's so difficult, and I suppose diplomatic protection is the thing you fall back on when there aren't other procedural remedies. The problem with diplomatic protection and individuals is really that question of political will then, because there are other well-known examples of say individuals whose human rights have been infringed, who for one reason or another can't attract the invocation of diplomatic protection. But at least in, and probably this doesn't quite answer your question, but as I was preparing for this, at least in relation to diplomatic protection and the question of investment in the areas beyond national jurisdiction, when it comes to activities in outer space, you then have huge degrees of influence by space investors and huge degrees of state engagement with the usability of space, given its military implications. And so that's an area where there's a lot of state engagement, there's a lot of willingness to use political muscle. As to whether and when we might see increasing use of diplomatic protection for individuals in relation to their human rights, I think it's very hard to say. Yes.
Thank you very much. Maria Fogdesna-Magius with Westerberg and Partners in Stockholm. Thanks so much, Angela. This was really thought-provoking. It's so interesting to take this perspective on things. I wanted to come back to what you mentioned, the Bering Fur Seals case, and I think what we're seeing now is a bit of a higher propensity towards realizing politically that we need to regulate areas beyond national jurisdiction for environmental purposes, for sustainability purposes, and so on. And so in that context, I was wondering if you had any reflections on the ongoing snow crab arbitrations. where from my admittedly limited understanding of those proceedings, you have the EU allocating fishing rights under various arrangements. And then you also have Norway purporting to essentially do the same under their fisheries protection scheme. And how does one reconcile those kinds of competing claims to be acting in an area beyond national jurisdiction? Thank you.
Thank you. I think that that example precisely illustrates this challenge of when you have this multiplicity of actors and different promises, different kinds of regulation coming from different states, different sources that aren't necessarily talking to each other and approaching things in a unified way. The snow crabs dispute is fascinating. And when I started preparing, I thought that my entire talk would be about the snow crabs. And for various reasons, I binned it. The snow crabs dispute, for those who don't know, concerns fishing for snow crabs in a loophole of international waters that's otherwise surrounded by the EEZs of Norway around the Svalbard archipelago and also of Russia. Now, it's been framed by the claimant as a dispute over in relation to fishing in international waters. But I think there's a real obstacle because there's a claim by Norway that they're sedentary species that belong to its extended continental shelf. And therefore, we're really talking about a claimant that's been arrested for illegally fishing without permission in an area that rightfully is within Norway's jurisdiction. There was a hearing about a year ago. There's an award pending. I believe the tribunal is chaired by Sir Christopher Greenwood. And so I'm very much looking forward to seeing that decision. There are a couple of observations that I can make about the case. One is that, in fact, I believe in Pildegovitz in Norway, which is that front runner case, the fishing licenses were actually issued by Latvia. And so, of course, Norway's arguing your dispute is really with the EU, it's with Latvia. We're not the ones who have promised you any ability to fish here on our extended continental shelf. I believe the claimant is arguing that there is a sufficient territorial nexus because the snow crabs are being offloaded and processed on Norwegian territory. And so that's something that will hopefully be resolved in the award. Mixed in within it are also, I believe, objections by Norway that there's also a monetary gold issue, that this isn't the kind of dispute that should be resolved before a BIT tribunal without the presence of Latvia and the EU. And then more recently, there's been quite a bit of a twist in the form of a new investor state claim threatened against the Kingdom of Spain in relation to snow crab fishing in these international waters. And you might wonder what that thing is. And I believe it's on the basis that I don't think I'm fully across all the facts, but within the threatened claim, I think is an allegation that Spain has violated the BIT because Spain has failed to exercise her diplomatic international means to claim the Spanish snow crab fishing quota under the EU fishing regime. And so here we're kind of coming full circle in a way to see an investor seek to use the BIT to apply pressure on Spain to take certain steps diplomatically. And that it's a very creative approach. It probably faces some quite significant obstacles, but it's very, very interesting.
The other one interesting element of the snow crabs case is that the way the claimants have gone about, although the case has been bifurcated, the claimants went about their preliminary investigations into issues of quantum, in that they certainly took preliminary advice from a number of firms, but not so much in purely a beauty parade, but the sharing of confidential information such that one of the firms that was not then selected as their quantum expert has been banned from any involvement on the other side. And so it's a big issue for the expert community, certainly.
So strategic conflicting.
Yes, exactly. Which used to happen in the divorce courts in England many years ago.
I'm sure it still does. There's a question that's come on the chat box. Would the effective control theory revive to give an answer regarding investments located within objective regimes, for example, regarding Antarctica, or once the North Pole completely melts down? Right? Gloomy question.
I think when it comes to, say, different parts of Antarctica that are claimed or de facto sort of administered by various states, it seems to me you might then have human rights jurisdiction on the basis of control. But I'm not so convinced that you would get territory as in the sense of BIT jurisdiction. I think you would find some support for that in the various, in some of the more modern BITs that offer a definition of territory, referring to land territory, territorial sea, continental shelf EEZ in accordance with international law. But I don't think that will quite take you to the North Pole or to Antarctica.
There's one more question online, although I'm not sure whether Jens still wants to ask this question.
Thanks, very kind. It's about parallels which were thought-provoking between various rules regarding the activities of contractors of the International Seabed Authority on one hand, and then various principles of international investment law on the other hand. So it's easy, of course, to see, but it's not easy. Separate examples are easy to see, but not the whole system. What could be the full scope of these parallels? One could say if on land mining is denied, it could be violation of minimum standard. And you could also not discriminate as an International Seabed Authority, for example. And then there is this contracts also, which the Seabed Authority has to continue and not arbitrarily discontinue. But what would be more? Could you a little bit exemplify more or explain the scope, explain these parallels a little bit?
I suppose the parallel comes partly from the fact that when we look at deep seabed mining in areas beyond national jurisdiction, it's effectively the International Seabed Authority that acts as a regulator. Now, precisely how it's going to do that is incredibly unclear, and it's still being worked out as we go along. At the moment, the ISA has issued, I think, just over 30 exploration licenses. There have not been any exploitation licenses, partly because the exploitation regulations have not been finalized. And in terms of what's happened factually, just over 2 years ago, Nauru had triggered a particular provision within the UNCLOS rules that entitles any state to ask the ISA to proceed to finalize exploitation regulations in 2 years. So that's been triggered. That 2-year timeline has come and gone. And I believe the ISA is now working towards the 2025 deadline to finalize the exploitation regulations. In the meantime, under UNCLOS, contractors can now seek provisional approval to proceed to the exploitation phase. I don't have the language in front of me, but it's essentially kind of based on the draft regulations or the spirit of UNCLOS. And that's the kind of uncertainty that really should strike fear into the hearts of any private investor. Within the rules of UNCLOS, there are, quite wide discretion is reserved for the ISA. And so it's also specified in UNCLOS that, for example, there is the right to challenge discriminatory refusal of a contract. And so perhaps there might be some parallels with the margin of discretion that's afforded to states. But at the moment, these provisions are very much untested. And so it may be that we'll find out.
Thank you. I think we'll try now, we're conscious of time, we're going to try and thread a needle through both of the very fascinating presentations that we've had. Just want to touch, and this is really opening it up, and also we're going to come on to a few quantum issues of time permitting. But let's just touch on the position regarding border treaties and state succession. And what's the interplay, and how does state succession work in the context of territorial border treaties?
Okay. So the rule under the Vienna Convention, which is now considered a customary international law, is that a new state is bound by the border treaties of the predecessor state. So in other words, if Quebec becomes an independent state, which is unlikely, but if it does, Quebec will be stuck with the border with Vermont or Maine, for instance. So this is a well-established principle, and no one is contesting that.
And so in terms of other treaties, is it broadly treaties that will run with land that you would say you're going to have, you know, a state succession on an automatic principle?
Yeah, so what I mentioned about a treaty would also apply to the context of navigation treaty, for instance, between the US and Canada with respect to the St. Lawrence River, which is part of it is Canada, part of it is international sea. So the international sea part, you know, Quebec would be bound by this treaty, even though it's as a new state, it was not party to it, and obviously it was not part of the negotiation, but it is bound for basic protection of rights reasons.
And again, opening it up to any of you, including any of the audience, what about human rights treaties? Where do they fit? We've spent a lot of time talking about territory, but human rights is always there in relation to the Public International Law Forum.
So many states have in the past said that they feel bound, like for instance, Slovenia, in the context of the breakup of Yugoslavia, said that it was bound by all human rights treaties to which Yugoslavia was party. So there is in doctrinal and scholarship, there is a tendency to believe that there is automatic succession to human rights treaties, because what is at stake is not so much the interests of states, but the protection of minorities, protection of individuals, etc. Whether or not such a principle of automatic succession to human rights treaty exists, it is not clear, but several states have taken position in favor of the existence of such a rule. So there's indication that few states are willing to take over all the human rights treaties, and that's a good sign of an evolution.
And you think that will continue, that trend will continue?
It's hard to say. I mean, it really depends on how much a state loves human rights.
Any questions from the floor in relation to those topics? Otherwise, I think I'll ask the same question to you, Angela, in relation to space. I think you mentioned that in the last sort of space convention was 1972. Is that no longer fit for purpose? Are there any plans for new legislation and new convention?
I guess it depends on what degree of consensus can be forged. That's going to be very difficult, but I think it is fair to say that it isn't really fit for purpose, in the sense that that convention comes from a time when space was dominated by public actors, and it would have been a time when commercial activity in space still seemed quite far-fetched, and that's very much changed now. And so there is a real need for change, but issues around how we regulate this space that's a kind of global commons and can't be appropriated by any one state is very much, it's very, very contentious. And you have on the one hand some states asserting their ability to conduct certain kinds of testing in space that generates significant debris, and others protesting very loudly about the risk that then poses to other actors in space. So they're all the sorts of issues that are very much the focus of ongoing discussion at the UN. Just a year or two ago, there was a UN General Assembly resolution urging states to refrain from anti-satellite missile testing. You know, of course, that's not binding, and I think consensus is going to be quite difficult.
And Andrew, just looking at the quantum of damages, and I'm not expecting you to say that you've looked at the quantum of damages on a satellite in space, but to what extent, when you're looking at quantum issues, are you being informed by the riskiness of the venture, and in particular thinking how risky deep sea exploitation is, or going into space, having commercial ventures of that nature?
Yes, I mean, risk is obviously very, very, very key and very central to any assessment of damages. I think the risk, though, one doesn't simply go to the discount rate that you might put to a cash flow forecast. And interestingly, just as an aside, I saw the $511 million. I would love to have seen a 19th century DCF pre-computers. Although one thing that did strike me, I tried to look for it, and what I found was that the modern multiple, your $17 billion, there are several different multiples. So I suspect that our own modern maths is not necessarily as accurate as it perhaps should be. But yes, so going back to risk, I mean, one needs to look at the factors. I mean, probably the easiest parallel is to a large mining opportunity. There, sure, you may have an asset which you've had assessed as being there, but you still there are all sorts of risks around. Can you finance the operation to get the stuff out of the ground? Is it economical to get it out of the ground? And that might apply now, but it might also to apply looking forward into the future. Is there going to be continued demand for that product? So there's a whole range of other risks that it's very difficult simply to tie it up into a discount rate factor, as I say, in a DCF. And I think that's one of the reasons where, when one is looking at these opportunities, it's always important, and there are some very big claims out there at the moment, based largely on DCF models, is to look at what comparative sales of similar businesses or equivalent businesses, often it obviously won't be an exact match, are making in the market today. And I think generally one finds that they are an infinitesimal piece of the totality of some of these big DCF calculations.
And we've talked, I think, two topics that drawing to a close the whole very interesting day. Human rights. How do you quantify human rights violations? How do you begin to quantify human rights violations?
Well, I think in our preliminary discussions a couple of weeks ago, I said I had never undertaken such a calculation. But I think there are perhaps there is some precedent beginning to emerge, particularly through class action litigation. So the collapsed mine in South America, there's class action litigation looking at compensation to be paid to the city that has suffered such terrible devastation. Going back to my time in Kuwait, there and just perhaps to educate some of the younger members in the audience, there was first regime change in Iraq. There was a scheme whereby compensation was paid into a fund, 30% of Iraq's future oil revenues, and then there was a system of audit and verification. And the claims were divided into 7 categories, A to F. Categories A, B, and C were all very much to do with individual loss, both personal, material, and loss of life, loss of limb. I had nothing to do with those claims, but there was at least a mechanism put in place under which individuals who had suffered harm and damage were being compensated.
And then looking at sort of that broader context of war and hostilities and so on, again, how does one bring into the context of things like, should the investor have mitigated in the face of increased hostilities? How do you take that into account?
I think mitigation can be very difficult because often hostilities happen overnight, or not overnight, but very quickly. But there are an awful lot of other issues that then do come into any assessment of damages. One of them is the quality of evidence. You've been kicked out of country, you've left all your machinery, your plant, your equipment, you've pulled your people out at short notice. What is the standard of evidence that you should be asked to arrive at in support of your claim? There are countervening factors. What about IT? Surely you have backup off-site. What about banking transactions with foreign banks, and so on and so forth? But that is certainly a very live debate, one which Katia and I will be discussing next week.
Absolutely. Questions from the panel? Yes.
Thank you for a very interesting presentation. My question is about
protecting investments not through investor-state arbitration? Because I imagine that when the respondent is unclear, then one of the ways how investors can protect their investments is through insurance. So first of all, have you heard of anything, any particularities of insuring risks such as deep in seabed mining or in outer space? And the second question, how does valuation comes into play here? Probably there are also ways to to have the insurance premium to calculate how much will be paid if the insured incident or event happens. Any thoughts on that? Insurance as a replacement for ISDS.
Yes, I think it's certainly part of the toolkit that any prudent investor should be looking at. And it's possible that a failure to take those sorts of precautions might then have implications for the success of a claim or the ultimate outcome on quantum. In relation to space and the risk of space debris, I read a headline. I don't know to what extent it's true, but I have seen headlines that space debris is increasing to a level where it's becoming uninsurable. So that's quite a striking illustration of the real problems that are, currently out of sight and out of mind for us here on Earth. But space technology permeates weather forecast, communication, internet access in remote places, surveillance. And there were reports, for example, that a single anti-satellite missile test a year or two ago had effectively doubled the risk of space debris collision. And I'm not a scientist, but I understand that at a certain level, space debris is quasi-eternal because it's in space. It's in space. At a certain level, it falls into the atmosphere and it's incinerated and it's sort of self-cleaning. But at a certain level, it's kind of eternal and it collides with other things and turns into smaller and smaller fragments that whiz around at 25,000 kilometers an hour or a second or whatever it is. So I think the private sector is also grappling with whether insurance is really commercially feasible in that context. And then at the same time, you have other private sector innovations. There are various startups working on ways to clean up, to vacuum up space debris, which is about as challenging as it sounds. And uninsurable. And uninsurable. And the risk is actually not just of actual collisions, because from what I understand, it's incredibly costly and difficult to avoid a collision. So once you have a satellite that essentially has to change its orbit to avoid debris, you have it requires tremendous amounts of fuel. It impacts the lifetime of the satellite. It's enormously costly. And so actually I think in a very, very real sense, there's damage caused to investments, even at the stage of avoiding space debris collisions. It doesn't only happen at the stage of catastrophic destruction and collision.
I think the other thing on political risk insurance, which is, interesting for those of us who have, practiced arbitration law for as long as I have, is that actually political risk insurance was something that when investors went in, particularly if they had financial backing, it was a tick box exercise. So you would go to your, and if you were a leading investment bank, okay, can we loan to this investor? They want to invest in utilities in Argentina. I'll come back to why that was the example I chose. And the bank's credit committee would say, have you got political risk insurance? And some luckless, broker had sat at the corner of some underwriter's desk and gone, no, can I have political risk insurance for Argentina? How much is that going to cost? Oh, I don't know. Nobody had ever really claimed on these policies. So they gave them political risk insurance. And when things went wrong, when the Emergency Act was enacted by Argentina, there were two sorts of arbitration claims. There were the investor state arbitration claims, and then those we all know about. But there were also mostly confidential commercial arbitrations under these political risk insurance policies, also providing cover for expropriation. I can guarantee you the people who are writing these policies had no idea what the legal meaning of expropriation was. What they certainly did once Argentina had taken action. And the other thing well, so then the first takeaway is, in my experience, the political risk insurance arbitrations paid out much more quickly, and were and there were either they were settled or there were favorable results. But by and large, the debtors, and because they were predominantly the banks that were loaning for these investments, were getting, you know, between 50 and 60 sort of cents in the dollar back. And then the other takeaway is that political risk insurance market collapsed because everybody in the market went, oh, we don't know what we're doing and we can't be offering that. I hear on the grapevine, and we hear from funders and so on, that the political risk insurance market is back. Why? Because the people who actually experienced what happened in relation to Argentina are no longer there. And you've got a whole new set of brokers and underwriters who are now beginning to underwrite in relation to political risk. Whether they will be prepared to underwrite space investment, I think, remains to be seen. But it's an extremely interesting concept as to how investment into space is going to get protected.
I think the insurers are back, but probably not for long, because there are many Russia-related insurance claims. I've been engaged in some of them with the Russian wives, and there will be many more because it's impossible to get any money from Russia in ISDS, right? So.
Exactly. And it comes back to a point that you made earlier as well, in relation to enforcement and enforceability. And of course, what was found in relation to Argentina in particular was that actually, if you get an arbitration award, a commercial arbitration award, you can enforce against, you know, an underwriter sitting in London or wherever. Enforcing against Argentina, as we know, proved a bit more tricky. I think unless there are other comments or questions, I think that has neatly taken us to the end of the session. So I'll pass back to you, Eric.
Thank you very much, Penny, for this very interactive session. And we ended sharply at 4:30. It's like a Japanese Shinkansen train, exactly on the dot. And it's my pleasure to invite Professor Tomoko Ishikawa from the University of Nagoya to make some concluding remarks based on what she has heard today, and also based on her own experience. We have been working with Tomoko for many years already, and we did events in Tokyo, we did events here. We recently completed a project on cybersecurity. Now we're working on a new project related to hydrogen regulation. And also Tomoko recently joined the ITF advisory board. Thank you very much. So if you missed some parts of the conference, don't worry, everything will be covered in this concluding remarks. You will hear the summary.
Thank you so much, Eric. So I'm honored to speak at this important event in commemoration of the founding of the 20th anniversary of the founding of the Investment Treaty Forum. Today, Professor Mendelsohn educated me on the history of the concept of territory, the concept of territory. If I may also talk about history, this year is the 420th anniversary of the Santa Catarina incident, which is considered as one of the founding events of international law. The Santa Catarina incident took place half a century before the Treaty of Westphalia's formal recognition of the sovereignty of the territorial state. This incident is closely related to the themes of today's forum, that is territory and investments, because it concerns extraterritorial conflict over the ownership of foreign private property. In February 1603, 3 ships of the Dutch East India Company attacked and seized a Portuguese merchant treasure ship, Santa Catarina, on the upper east coast of what is modern-day Singapore. The ship's precious cargo was swiftly dispatched to Amsterdam for auction. The seizure of the Santa Catarina was not authorized by the Dutch Republic and therefore could be considered as an act of piracy. Therefore, the Dutch East India Company were compelled to provide legal justification for the incident. The company commissioned a young lawyer, Hugo Grotius, to write a formal justification. The treatise he wrote is now regarded as one of the most important sources of the law of nations. Professor Schroer also described that legal principles concerning the protection of investor nationals were developed in the context of gunboat diplomacy in the late 19th century, when European states and the United States exercised aggression against weaker Latin American states in order to collect financial debts owed to the citizens of the aggressors. The Carbo Doctrine, which is also an important concept in international investment law, it emerged in this era as an effort to overcome the unequal economic relations they had with capital exporting states. I think it is interesting to see that the origins of international investment law lie in the extraterritorial ambitions of states and quasi-sovereign entities. Centuries after, currently, international investment law faces classic and novel challenges concerning territory. Today, I had the privilege of hearing excellent discussions on these challenges. Issues concerning state sovereignty in international law were discussed. It appears that this concept of state sovereignty has increasingly posed challenges to investment law, and I think this can be considered, at least partially, as a revival of the Carbo Doctrine. Janssen discussed German courts' inconsistent attitudes towards the treatment of intra-EU arbitration. We can also recall that recently in the Costello case, the Irish Supreme Court concluded that the investment court system under CETA in its current form interferes with Ireland's judicial sovereignty. This judgment, the Colony Court's judgment in RWE and Uniper, and a series of Court of Justice of European Union's decisions, including Akimia, Comstroy, PE Holdings, all share some traits with the Carbo Doctrine in the sense that they emphasize the jurisdiction of the host state and European courts. In addition, the domestic courts of certain states have asserted their powers not to recognize or enforce exit awards on the grounds of public policy or constitutional considerations. This suggests that the Carbo Doctrine, more than 100 years after its conception and in a very different context, has been revived and has started to challenge investment treaties, the investment law regime. We also have the issue of whether and how foreign investments are protected in times of armed conflict between states or within a state. As Professor Schroer mentioned, the first investment treaty-based arbitration was AAPL versus Sri Lanka that arose from armed conflicts between Sri Lankan forces and Tamil rebels. It is sad that after more than 3 decades, this question has not only persisted, but also even gained importance today. We have the preliminary question of whether or not the outbreak of armed conflict affects the continued application of investment treaties. Again, Professor Schroer concludes that the ILC draft articles on the effects of armed conflict on treaties suggests that investment treaties continue to operate in times of armed conflicts. This leads to a set of difficult questions, including the interpretation and application of full protection and security standard in the context of armed conflicts, as Professor Ortino discussed. Dr. Costello, Professor Mendelsohn, Professor Schroer, and Ms. Pinker, like they all addressed the question of whether the obligation of non-recognition of illegal territorial acquisition should bar the tribunal from applying investment treaties to illegally annexed territory. In a situation where non-recognition actually benefits the occupying power. I would like to mention an observation provided by Professor Dunbury in his article, which was not specifically mentioned in today's sessions. It is about the distinction between investment treaties on the one hand and international human rights and humanitarian laws on the other in this type of situation. Professor Dunbury argues that, and I do agree, is the latter, international human rights and humanitarian laws are intended to protect local populations in the occupied territory and should therefore bind the occupying force. This does not squarely apply to investment treaties. On the other hand, Mr. Bose and Professor Bortella discussed the moral aspects surrounding investment protection in Crimea. Certainly, if the obligation of non-recognition extends to arbitral tribunals, which didn't happen, but investors in the occupied territory will be left in a legal vacuum. The territorial limitations of investment treaties bar ISDS tribunals from attributing blame to third-party aggressor states. In their current form, investment treaties offer no remedies against aggressor states, which caused damage to investments existing in the territory of another state which it has attacked. This is a limitation of investment law. As Professor Schroer suggested in his articles, this underscores the need for a multilateral effort that reflects the principles of private property protection in times of armed conflict. It would be great as a way to fill this gap in investment treaties if states could set up an international tribunal that deals with matters relating to the reparation of investors' losses during armed conflict. However, this would be simply politically difficult to achieve. I would like to briefly discuss an issue that was not discussed in today's sessions. Armed conflicts also create relationships between investment law and economic sanctions. Russia's invasion of Ukraine resulted in a wide variety of economic sanctions against Russia, Belarus, and individuals and the entities in these states. Russia, in turn, has imposed counter-sanctions against unfriendly nations. Sanctions and counter-sanctions include asset freezes, cancellation of contract, nationalization of foreign intellectual property without compensation, and the list goes on. Naturally, all of these are unilateral sanctions that are not based on a United Nations Security Council resolution. Multilateral sanctions based on Security Council resolutions prevail over investment treaties, whereas unilateral sanctions do not. Therefore, unilateral sanctions may amount to a breach of various investment protection and liberalization obligations, such as expropriation, fair and equitable treatment, free transfer, etc. If an investor brings a claim against a sanctioning state, it also requires an assessment of various defenses, such as countermeasures, the denial of benefits, necessity, non-precluded measures, and security exceptions. Investment disputes may also involve investments in the sea, outer space, and cyberspace, all existing beyond territorial borders. Ms. Ha discussed that this gives rise to the questions of territorial nexus, who to blame, and what remedies are available under international law. This also gives rise to a question of how different sources of law and fields of international law interact, such as the UNCLOS and the Space Liability Convention. And in panel 1, Ms. Ambos also mentioned the challenges cyberspace would pose on investment law. And let me add a few words on cyberspace and investment law, which was not specifically covered in today's sessions either. So cyberspace and digitalization pose new questions, such as whether cryptocurrency can constitute protected investment, cryptocurrency that exists in a blockchain, and it cannot be pegged to any particular jurisdiction. In particular, whether they can be equated with financial instruments to qualify as investment and pass the Abaclat Tribunal's territorial nexus test would be a difficult question. I think I'm running out of time. So to conclude, investment law is at a crossroads. We all know that there are ongoing discussions on the substantive and procedural reforms of the investment treaty regime. Any considerations of reforming the current regime should be based on a careful assessment of what can be done within the existing current framework and its limitations. The Investment Treaty Forum has contributed vastly to this purpose by identifying the challenges that investment law faces and by addressing possible responses and solutions. I would like to conclude by offering my sincere congratulations on the 20th anniversary of the forum. Thank you very much.
Thank you very much, Tomoko. And yeah, that concludes the formal part of our conference. Thank you very much again to all the speakers, all the participants in the room and online. There will be drinks here in this room. Actually, the drinks are already there. And I will see some of you at the dinner kindly sponsored by HKA. Thank you very much and see you at other events in the future.